Strategically located along the 21st century maritime Silk Road, Sri Lanka, the pearl of the Indian Ocean, the key link between the East and the West, offers access to a thriving region poised for accelerated growth. Rising from the seas of Sri Lanka, Port City Colombo is a large-scale reclamation and city development project undertaken jointly by China Communications Construction Company, a Fortune 500 company, and the government of Sri Lanka. Spanning 269 hectares, Port City Colombo, when fully developed, will have a total gross floor area of more than 5.7 million square meters. A modern city where people can work, live, and play. The government of Sri Lanka is actively working on turning this into an international financial city. With new commercial legislation modeled after British laws, coupled with preferential tax, custom, immigration regulations, and other attractive policies, Port City Colombo will attract top multinational corporations and global talent. A state-of-the-art convention and exhibition center capable of hosting large-scale international events will position Port City Colombo as the new hub for business and MICE activities in the region. Port City Colombo will also be the pioneer of the smart city concept in Sri Lanka, where IT expertise using cloud computing and the latest cutting-edge technology creates a seamless living environment, making smart living, smart working, and smart estate management a reality. Port City Colombo has adopted the latest sustainable city concepts, with emphasis on a people-friendly environment using the transit-oriented developments concept to minimize commuting, further enhances the project's sustainability. Port City Colombo will be the most livable city and desired travel destination in the South Asian region, with a 2-kilometer sandy beach, a water channel that flows through the middle of the city, a central park with lush greenery and park connectors traversing across its length and breadth, with the best of healthcare and education. Port City Colombo will be amongst the very best top international cities, world-class hospitality, integrated resort and theme park, a retail destination that is home to the best of international brands and local retailers, a luxury marina, will make Port City Colombo a top tourist destination. Building a world-class city for South Asia. Port City Colombo.
Welcome to the webinar on new regulations of the Port City Colombo. In fact, discussion of the new Act of the Special Economic Zone with opportunities, legal implications, and contractual issues. Firstly, let me say good afternoon, good morning, good evening, and even to some good night, because we have participants who are with us from the globe watching this webinar. To begin with, let me place on record the appreciation of the organizers, Asian Pathfinder, Legal Consultancy and Drafting Services, to our main sponsor, Czech Port City Colombo Private Limited, and the exclusive media sponsor, Daily FT. We have 4 presentations lined up. We will start with Mr. Tulsi Aluvihare, who is the Assistant Managing Director of Czech Colombo Port City, who will make an overview of this new initiative, followed by Dr. Dana Jayasuriya, former Chairman of the Securities and Exchange Commission of Sri Lanka, President's Council, will be the next speaker. And we also have Dr. Asanka Gunawansa, who has been with the regulations of the port city for a considerable period of time, who will speak to you. And after that, we will take on questions and answers. We'll as much as possible try to answer the queries and the questions that have been you have with you. We have already got a couple of questions lined up. I'm sure you're going to find answers for those questions during the presentations by our speakers. I wouldn't want to take much time, but move on with the presentations. The first presentation, an overview and an introduction to the port city by Mr. Tulsi Aluvihara, Assistant Managing Director of Czech Colombo Port City Private Limited.
Thank you, Malik. Good afternoon to everyone. Thank you for Asian Pathfinder organization for organizing this pertinent topic to be discussed today. I have a brief presentation. My presentation is structured in a way I will give you a quick brief progress update, followed by just a description of the arrangement between the government of Sri Lanka and the project company, what that commercial arrangement is, and also look at the history of FDIs, especially in the services sector, towards Sri Lanka, and the need for an SEZ or a special economic zone law to be established or implemented within the Port City Area of Authority for this project to be successful. So landscaping and utility corridors development are in progress. The roads, foot and vehicular bridge are under construction. And majority of the infrastructure works we hope to complete mostly before end of this year, and the remainder by mid next year. So of the 1.4 billion foreign direct investment committed by the project company, so far 1.12 billion had been invested. This is as at March 2021. And also Port City was declared under the Colombo Administration District in August 2019. There were 3 rounds of EIAs with public comments was concluded. 2 EIAs for reclamation and all internal infrastructure development, and the third EIA was for vertical development. On the EIA, I must emphasize that on the second EIA, we received over 215 written submissions, and there was a expert committee appointed to address those, and there is what is called an environmental management plan in place. And the license that was issued to the project company has 72 conditions to adhere to. The development control regulations was approved by the UDA and ready for Gazette. Development control regulations are regulations where each developer who wants to develop within Port City has to adhere to these detailed guidelines. As we speak now, 100 hectares of land is ready for construction. As all of you may know, Colombo Port City Economic Commission Bill was approved by the Cabinet and Parliament and was enacted last week. In addition to the $1 billion investment, Colombo International Financial Center mixed use project, a further 1 billion investment, the project company has come forward to make that investment in 2 phases. And for the phase 1, we have also partnered with a local conglomerate to develop that. The scale of the Port City project, so the total, the chart you see on your left is the total 6.3 million square meters of gross floor area that is divided into predominantly residential, commercial, retail and other. The residential part is close to about 50% of the total GFA. That's about 3.2 million square meters. And second is the office, about 1.5 million square meters, followed by retail and hospitality. So there are 74 marketable plots within Port City. Now the allocation between the project company and the government of Sri Lanka is quite important. So in return for the 1.4 billion investment made by the project company, Government of Sri Lanka will have issued or given leasehold right for 116 hectares. That's what you see on the chart on the right hand side. So the GOSL land component is 153 hectares, about 57%. Now that 57% is divided into what is called common areas, which is 91 hectares, and 62 hectares of marketable land. So 1/3 of Port City, 91 hectares, is accessible by general public. And the 74 marketable plots are divided into 28 land plots for the government of Sri Lanka, and we have 46 plots to be developed. Next. I think it is important to understand that GOSL will hold the freehold title of all 269 hectares of reclaimed land. As I mentioned, in return for the investment made, 43% of the land area is given as a leasehold right to the project company. Now, what is important to understand is that we as a project company is not going to be developing on all those 116 hectares. We are looking, or we are appealing to the international investor community to come and invest in these land lots within Port City. And once we identify third-party investors, we will surrender our leasehold right. Government of Sri Lanka will enter into a fresh lease agreement with the potential investor for 99 years, and in surrendering the leasehold right, we receive the consideration. So it is important to emphasize that the landlord within this area of authority or Port City is always the government of Sri Lanka, and they will be a party to any lease agreement signed within this area of authority. The table on the below gives you at today's cost the marketable value of the land. The total is about 4 billion for the project company, and government of Sri Lanka has an asset of 2.5 billion, plus the common areas of about 500 million. The point I'm trying to make is this asset has been now created. We have close to a $7 billion asset at today's market value created or extending the existing CBD of Colombo. Now the question is, how do we monetize this asset? Next. So this is the development timeline. As I just mentioned, most of the infrastructure should be completed before end of this year, landscaping by mid next year, 2022, and all electricity connections to phase 1 plots would be by November 2021. It is important to bring Port City to life. So what we have done is we have opened an aqua golf range in September 2020, which was open for public. Obviously due to COVID, you're not able to patronize it now. Further, we are looking at a beach club also to be opened, a go-karting track. So the creating footfall is quite important for us. Commencement of the CIFC, or the Colombo International Financial Center phase 1, and a downtown duty-free. We will break ground for both of those development before end of this year. And you will see the marina development coming up quite shortly, and we hope to complete that by 2022, or failing which first quarter 2023. Strategic infrastructure plots, which is the international school, hospital, and the convention center, will be completed by 2025. And completion of CIFC phase 1, and also over the next 10 years, we hope to complete the phase 1 of the Port City development, ideally by 2030. Next. Yeah, this is the Port City master plan. This is a 2.7 square kilometer reclaimed area. The legend, as the legend shows, the color code shows the purpose and use of those development from pure commercial, residential, recreational, and Most importantly, there's a theme park integrated resort, a largest plot within Port City, about 15 hectares. Next. So the master plan is divided into two phases. This is predominantly really for infrastructure development. So all the required internal utility infrastructure, landscaping, road network, all would be majority completed by mostly end of this year and some mid next year for phase 1. It is important to highlight that of the phase 1 plots, there are 74 hectares, majority is identified for commercial development. The color codes, darker color codes highlight commercial development. So 74% of the gross floor area is allocated for commercial development, which means trade and commerce has to happen for us to be able to be successful in attracting demand for these plots. Next. And we definitely need a GDP growth of more than what we're experiencing at the moment, almost lowest in South Asia. So phase 2, the lighter colors, if you look at it, those are predominantly residential development. So the idea or strategy here is that if we are able to promote trade and commerce, we will be able to be successful in attracting demand for phase 1. Therefore, phase 2, which is predominantly residential towers, we will be in a much better position to position those plots for not only locals, for expats, plus a wider business community who will locate in Port City to do their business, or multinational companies setting up their headquarters within Port City to access the region. So that's how the master plan is devised. I think it is important to really, now this is, Port City is no doubt an ambitious project. It is important to really identify the landscape, historically what has Sri Lanka done in terms of attracting FDI. Honestly speaking, we have really fared below par, not being able to attract a fair share of our FDI. Now if you look at that chart on the top, 2017 and 2018, we have managed to go beyond $1 billion FDI. That is predominantly driven by Hambantota Port investment. So the point I'm trying to make is there is significant lack of new investments, greenfield investments coming into Port City, and all our FDI, if you look at the last 10 years, predominantly have been in telecommunication, property development, or in ports. Now the chart on the bottom shows that of these investments, how much is reinvestment? Because when these foreign companies invest in Sri Lanka, their reinvestment is accounted as an FDI. So if you look at the last 2-3 years and take an average of the total FDIs, close to 50% have been reinvestments by existing foreign companies. So that really paints a picture that we have really been struggling to really attract new greenfield foreign direct investments into Sri Lanka. So this is another slide to really show sources of greenfield FCI essentially in the services sector. So if you look at from electronics to IT to financial services, the lowest column identifies how Sri Lanka has fared compared to rest of the region. I mean, even in IT or financial sector, we have barely managed to attract 1% of the FDIs which are out there in the emerging Asian, compared to emerging Asian countries. This begs really a question as to why Sri Lanka, which strategically located and also boast about an English-speaking population, high literacy, high human development index, have managed or have not managed to attract its fair share of FDIs into the services sector, which contributes close to 60% of the GDP. So if you look at the services sector growth in the last 5 years, as the top chart shows, we have shown a negative growth in the FDIs into the services sector, which is highlighted in that green bar. It's a negative growth, and last year, or in 2019, FDI contribution to the service sector as a percentage declined to 19%, which was 26% in 2015. Chart below is quite interesting. That shows the number of applications to the BOI and what really transpired as contracted. So almost 50% have not been able to, 50% of the contracts signed have not been able to really crystallize. So what it means is that because of the existing bureaucracies and stringent approval process means that we have failed to really convert some of these BOI applications into real investment opportunities. Right, let me talk about the Port City SEZ and tool to attract. Some snippets, I'm sure, after me, two speakers, Dr. Dayanath and Asanga, will talk to you in detail. I think one of the key provisions in the bill is the single window investment facilitator, where the Commission will facilitate all applications approval to do business, to invest in Port City, is through one-stop shop, and we expect the Commission will expeditiously address these applications and approve these applications and function as an efficient organization to address some of those doing business issues we face in rest of Sri Lanka. A friendly tax regime, so the thinking is that companies set up in Port City would be considered non-residents, and their foreign source of income will be taxed at 0%. In addition to that, for larger strategic investments, with large investments, there is a guaranteed tax holiday up to 40 years. Foreigners can own 100% of companies set up in Port City. There is no restriction on shareholding. Focus on investment protection is quite key. There is a specific provision given in the Port City Act that no registration, license, authorizations, no any agreement that the Commission enters into with a potential applicant, which becomes an authorized person, can be revoked arbitrarily. There's an international dispute resolution center to hear any arbitration there. So the idea there is, if you look at doing business index, I will show you next. Now we rank 99 of 190 countries. This is our ranking if you look at the region. Next. And the chart below shows how has India and China had fared in the last 5 years. Now if you look at Sri Lanka, we were 99. 5 years later, we are still there. Whereas India and China have progressed significantly, 130 to 63, India and China from 84 to 31. So there is significant competition by some of these regional countries, and what we need to understand is there is a lot of reforms being undertaken by some of these regional and developed countries. So what are we trying to address within this Port City Special Economic Zone? As I mentioned, I've just discussed the poor track record of the country in attracting foreign direct investments, and we need to ask the question why. Some of it is predominantly because of our poor performance in doing business in Sri Lanka. So doing business is analyzed or evaluated over 10 verticals. So by virtue of implementing this law, implementing efficiently, I must say, some of these pain points will be addressed immediately, from starting a business, construction permits, getting electricity, registering property, also in terms of enforcing contracts and priority hearing in civil and commercial legal proceedings. These are key pain points where investors really are quite, what can I say, distressed in terms of when they come to Sri Lanka to do business, because what is important is that these investors, when they identify a location to relocate or expand, they shortlist more than one country, and they compare cost of doing business, cost of living, and ease of doing business. So with the Port City SEC law, we expect most of these pain points would be addressed immediately. These are several countries who have developed economic clusters and their positive impact. Dubai, DMCC and DIFC are significant contributors to their GDP. For instance, Dubai contributes 10% of their GDP. And China's experience, the Shenzhen, it was a fishing village 30 years ago, now produces over $400 billion in value to the Chinese economy. And Labuan, the Malaysian International Financial Center, have been also quite successful. They have about 50 banks, global banks set up there. Of that, about 10 or 12 are global investment banks. So we can really look at some of these SDGs or economic clusters have worked well and take learnings out of that as this port city or city evolves. I think this is another couple of examples which is quite important. I think what we need to understand is competition for capital and human capital. Intensified more so will be post-COVID. If you look at UAE, they have embarked on several reforms to attract talent, to attract investment. Companies now in UAE are allowed to own 100% outside the free zones. Before 2021 January, foreigners were not permitted to own beyond 50% of any company outside free zones in the UAE. And also they have introduced what is called a 10-year golden visa to attract professionals and their families to relocate to UAE. India is an interesting example. So India started this SEC process in 2005 with the SEC Act of 2005. 10 years, 15 years down the line, their SEC experience has not been that great. They have over 300 SECs established, but I don't think they really reap the benefit that the government of India expected. One of the main reasons behind that was the authority that was established to manage and govern these SEC lacked the economic and administrative autonomy, where for each and every or most decisions they had to refer to the central government, and that really created that bureaucracy that was already inherent in the system. And the authority also was housed by some of the secretaries of the ministries. So you are creating a system that has failed already. And what the Indian government has done is more recently has set up a commission to identify where they went wrong, and they have more recently implemented what is called International Financial Center Services Center Authority Act in 2019. Actually, that act came into force, where the financial services regulator, that is the Reserve Bank of India, the stock exchange or the Securities and Exchange Commission, their insurance regulator and their pensions regulator, all these regulatory bodies were brought under one roof as a regulator for all financial services companies set up within this SEC, under this SEC Act, to be regulated under one regulator. I think that's quite a progressive step. So which means they have elevated, all these existing regulators have elevated or vested their powers in this apex body. So that's a key reform. And also they have partnered with other like Luxembourg stock exchanges to promote ESG and green finance, where you have an opportunity to dual list in India as well as in Luxembourg. The point I was trying to emphasize is developed and developing countries are embarking on massive reforms to attract investment and talent, and we need to, if we are to compete, we need to also embark on such bold reforms to be positioned attractively in the global and regional investor radar. these are another examples of some of the things that Singapore is now actually granting 2-year, they are promoting entrepreneurs to relocate. They give 2-year entry visas first, followed by a permanent residency and followed by a citizenship. So they're trying to attract doctors and professionals and IT professionals to relocate to Singapore. Headquarter businesses, if they were to locate, they can even get full tax exemptions. Shipping companies are fully exempt from taxes. Then there are concessionary tax rates on other sectors like the freight and logistics operations. Singapore is also embarking on massive startup ecosystem to attract entrepreneurs and innovators, where based on your first 3 years, your certain amount of income, as the chart shows, will get a 75 to 50% tax exemption to promote startups. If you ask me what were the priority sectors for Port City, would be the chart shows the ease of winning and attractiveness. So on the top right, which is highlighted in green, talks about international trade, logistics operation. These are natural strengths we have. We just, with the advantage of the location, we just need to promote them and have the enabling provisions or competitive regulations in order to attract this. Obviously, hospitality tourism, we still, as a nation, we have the destination appeal for tourism. I think what was lacking was the destination appeal for businesses, which we hope to really address through this new Port City Special Economic Zone law. What is shaded in the middle, which is ICT, offshore banking, these we need certain enablers for us to, for Sri Lanka to put on the global map as a destination. And the framework law which was implemented, I think, is quite progressive, but it's only a framework. So what you need is now required regulations to be framed under this law, and these regulations, I hope, would be more market driven. You know, the Commission would need to speak to the market, understand who the anchor tenants are, who these large anchor multinational businesses who will look to relocate, speak to them, and the regulation making has to really follow market driven approach rather than the other way around. Innovation Hub is quite key, I mean, for launching of startups, especially for tech startups. For a financial services or a multi-service sector to thrive, you really need to promote innovation and need to create that ecosystem promoting entrepreneurship. As a nation, we invest less than 0.1% on R&D, so that's why we have really lagged quite far behind on innovation, and we hope a massive, this is going beyond Port City. I think a much more government championing approach is required if you were to really position Sri Lanka, Colombo as an innovation hub. So this is our rollout strategy. With the law being implemented, what we plan to do is collaborate with some of the industry associations, the chambers, to really promote Port City outside Sri Lanka. That is quite in the region. So we have identified some of the key markets: India, Singapore, Middle East and China, and we have already appointed some of the marketing agents to promote Port City there. Series of virtual events such as this to promote awareness for a global audience will continue until travel reforms, and after travel reforms we plan to have series of physical events to promote this project regionally and globally. So this is our strategic plot rollout plan. We have identified 20 plots. We have identified 20 plots which are highlighted there, which varies from pure commercial recreation to integrated resort. So these 20 plots consist of 60 hectares. An investment of about 5 billion is required for us to complete this 20 plot development, and we hope we can achieve this in the next 5 years as pilot projects. Goes without saying, I think many of you may have seen many literature on benefits of port city for Sri Lanka. I want to really emphasize on the supply chain impact of this port city project, where based on this law, goods and services can be procured or supplied from rest of Sri Lanka to port city, and it would be a deemed export because transaction currency within port city is foreign currency, any designated foreign currency. So there is significant opportunity for small and medium enterprises who really lack the scale and due to compliance issue was not able to tap into the export market. Now you are really creating that export market in your backyard. In addition, professionals, engineers, accountants, lawyers will have great opportunity now providing their services in port city for large multinational companies who will set up in port city to do business elsewhere or to access the region. And another key point is that interim provision, which allows in the next 5 years until buildings come up in port city for any company to locate elsewhere. As you all know, we have a bit of a struggling real estate market, especially in Colombo, with a lot of vacant properties. I think it will be a much required boost in the next 5 years for them to really drive occupancy through this interim provision until port city really comes to life. And more importantly, ability to incorporate learning from port city into a wider economic reform agenda, because this is a ring-fenced area and some of these policies can be implemented and tested. And once you get it right, I'm sure these can be rolled out in rest of pockets of Sri Lanka, like how we did the Board of Investment, identified those export processing centers, started with Katunayaka, but we have close to a dozen rolled out in Sri Lanka. I'm happy to take any questions. Thank you.
Well, thank you, Tulsi. That was a very comprehensive and a very lucid presentation on the port city. As Minister mentioned last week, that this perhaps might be the turning point for Sri Lanka's economy and also for the region, and making the goal of making Sri Lanka that paradise is something which I think every Sri Lankan will want to visualize. We started this webinar, actually we started it as a seminar. Unfortunately, with the COVID restrictions, we couldn't do the seminar. We converted it to a webinar. And the seminar and the webinar initially was done with the intention of discussing the bill. But let me tell you, there is an act before us right now. It is Act number 11 of 2021, certified on the 27th of March, 27th of May. And with that act, we see a new commission, 7-member strong commission being appointed to administer the port city. Tulsi also mentioned very validly that Sri Lanka is richer by over $7 billion with the land being capitalized. That is certainly a good sign. Let me now move on to our next presentation. We have Dr. Dayanath Jayasuriya, former chairman of the Insurance Board of Sri Lanka and former chairman of the Securities and Exchange Commission of Sri Lanka, and a legal professional locally and internationally, the senior partner of Asian Pathfinder Legal Consultancy and Drafting Services, who will make his presentation now.
Good afternoon, ladies and gentlemen. At this stage, let me add a special word of welcome to our foreign participants. We have participants from Australia, China, Singapore, Japan, India, USA, Canada, Gabon in Africa, Middle East, and from the UK, from different cities such as London, Manchester, Belfast, and Cambridge. The order of the Supreme Court, I think, is a landmark judgment. It's a case where 96 counsel, including 19 President's Council, appeared before the Supreme Court. Altogether, there were 19 petitioners at the beginning, and later 14 petitioners sought to intervene. In my legal practice of 48 years, I don't think I have ever seen a bill with so many amendments to be introduced at the committee stage. The Additional Solicitor General, Mrs. Jamil, did a great job in trying to salvage the bill by proposing many changes, and the Supreme Court itself suggested alternative wording. But the problem here is that neither the Attorney General nor the Supreme Court has any control over what happens at the committee stage of the Parliament. Now, in terms of the Constitution, one of the functions of the Supreme Court is to examine draft bills presented in Parliament as to their constitutionality and look at the wording and decide whether certain provisions require a special two-thirds majority and a referendum. But there's also another subsection in the Constitution which says that the Supreme Court may suggest alternative wording. But the problem there is that the Supreme Court's proposals can be totally ignored at the committee stage. The Honourable Speaker did sign the bill into the form of an act before the Hansard of the 19th and 20th of May were available. And we have actually had no opportunity to check what really went on at the committee stage and whether the proposals submitted to court and the proposals by the court were finally accepted and incorporated into the Act. What I propose to do is to provide a very brief overview of the Colombo Port City Economic Commission Act and then refer to some of the current and emerging challenges. My colleagues, Dr. Asanga as well as Malik, will amplify some of the matters which I will be briefly making reference to. It's always useful to look at the structure of the Act, and the Act has 76 sections. The first part deals with the establishment of the Colombo Port City Special Economic Zone and the Commission. The second part deals with the objectives, powers, duties, and functions of the Commission. The third part deals with the composition of and affairs of the Commission. Part 4 deals with the fund of the Commission. Part 5 deals with the Director General and the staff of the Commission. Part 6 is an important section. It deals with the application for and approval as an authorized person, the agreement required to be signed, the single window investment facilitation, Sri Lankan citizens engaging in business, employment, purchasing, leasing or renting property, or utilizing facilities or services. Part 7 refers to offshore companies to operate within the area of authority of the Colombo Port City, and Part 7 provides for offshore banking business in and from the area of authority of the Colombo Port City. Part 9 deals with the determination and grant of exemptions or incentives for the promotion of business of strategic importance. And in the schedules to the Act, there are certain listed laws which will not apply, and there is also another list which may apply in certain instances. Part 10 deals with the applicability of the Condominium Management Authority law and the apartment ownership law. One of the points we need to keep in mind is that the legislation doesn't envisage an industrial zone to be set up as such. It's going to be mainly residential in nature, plus having the headquarters of officers and so on, and there is something which makes the Sri Lankan port city different from some of the free trade zones that operate in other countries. Part 11 deals with the applicability of the Securities and Exchange Commission Act, and my colleague Malik, who was former Director General of the SEC, will deal with that part of it. Part 12 deals with the estate manager for the condominium property and the provision of general services. Part 13 is an interesting topic, and Dr. Asanga will, I'm sure, have some comments to make. It's on the International Commercial Disputes Resolution Center. Then part 14 deals with priority in hearing legal proceedings. Part 15 deals with interim provisions and investment protection. And part 16 deals with miscellaneous provisions. Who are some of the important functionaries and agencies under the legislation? The President is mentioned in many sections, but within parentheses it says, or in the event that the subject of the Colombo port city is assigned to a minister, it will be a reference to such minister. So there are some sections, a few sections, which refer only to the President. For instance, the appointment of the Director General can be made only by the President and not by any minister to whom the subject has been delegated. So then there is the Colombo Port City Commission. Then there is the Director General who will be the CEO of the Commission, the Securities and Exchange Commission, Registrar General of Companies, and there are references to certain regulatory authorities. And finally, there is the International Commercial Dispute Resolution Center. As far as individuals and corporate entities are concerned, the term authorized person is important because anyone who wants to start business, buy property, take a lease and so on, will be designated as an authorized person subject to terms and conditions. Then there's a reference to the project company, and as we know, we know what the project company is, and they have already reclaimed land and now trying to market the project. And there's provision for an estate manager, basically to supervise and manage the condominium property, etc. Looking at some of the selected definitions, as I mentioned, so the master plan means the plan of the Colombo Port City, which provides a conceptual layout to guide future developments of the Colombo Port City. Offshore banking business means the provision of banking or financial services by an authorized person as permitted under this Act, payable in any designated foreign currency other than Sri Lankan rupees, unless as provided in terms of this Act or as may be prescribed. And the final definition to which I would like to draw your attention is offshore business. It means the provision of services, including financial services, by an authorized person as provided for in terms of the Act, and where remuneration is payable in any designated foreign currency other than Sri Lankan rupees, unless as provided in terms of this Act or as may be prescribed. Well, let's look at the Port City Economic Commission part of the Act. It's entrusted in the manner set out in the Act with the administration, regulation, and control of all matters connected with businesses and other operations in and from the area of authority of the Colombo Port City. The Act provides for up to 7 members, and even though there was no indication in the bill that foreigners will be appointed, there was speculation in the media and in Parliament that foreigners might be appointed, and therefore the Supreme Court in its judgment said that the majority of the members shall be Sri Lankan. The quorum is 5, And just yesterday or day before yesterday, His Excellency the President appointed 7 members. I wish them all the best in this major endeavor. The Act specifies 10 objectives to be achieved by the Commission. Now, with regard to the powers, duties and functions of the Commission, these are enumerated in 35 subsections, and I'm not going to deal with those subsections. But it does exemplify the wide-ranging nature of the powers, duties and functions of the Commission. So that would be the apex body which will be able to handle and guide the regulation and control of the operations. There is provision for regulations and rules. The President, or in the event that the subject of the Colombo Port City is assigned to a minister, such minister may, in consultation with the Commission and any relevant regulatory authority, make regulations in respect of all matters for which regulations are required to be prescribed or authorized by this Act to be made. These are set out in 20 subsections covering a wide range of matters. Additionally, development control regulations for the implementation of the master plan have to be enacted. Rules have to be enacted. Then there are the community rules, particularly for the management of condominium property, would have to be drafted. So there's plenty of work to be done by the Commission for the Act to become fully operational. So there are certain gray areas to be clarified. One is the scope of boundaries in Schedule 1 to the Act. Now, for instance, if you look at lot number 7, the south and west boundaries are described as the Indian Ocean. And there can be implications of the rules relating to territorial waters, whether any investor setting up a business can have trawlers or ships near or inside our territorial waters. There can be certain issues, even though international maritime law makes it clear that you cannot enter territorial waters without prior arrangement. The second is that, and this is a question which some of the investors whom our law firm has contacted asked us, is what is the security of government assurances for the project company? Because the project company is doing advertising and trying to raise capital, trying to find investors and so on. And even though they have entered into an agreement that hasn't been attached to the bill, nor has it been made a public document. Then there are questions regarding the powers of the Registrar of Companies with regard to offshore registered companies. Those of you who are familiar with the Companies Act know that the Registrar of Companies has very limited functions and oversight over offshore registered companies. Then there is an issue regarding the regulatory reach of the central bank over offshore banks. Then there's another issue about the regulatory reach for regulating gambling, stock exchange, etc. There's provision to set up a stock exchange within the port city, but until then the Colombo Stock Exchange will remain as the only exchange in Sri Lanka. With regard to the master plan, the Commission has to approve with the concurrence of the President or the Minister. The other day, I did hear some ministers of the Cabinet saying that the master plan has already been finalized and approved, but in terms of the Act, it is the function of the Commission to finalize it and seek the concurrence of the President or the Minister in charge. In several sections of the Act, there is the expression in and from the area of authority of the Colombo Port City. Now, if it is confined to in the area of authority of the Colombo Port City, there are no questions. But if it says from the area of authority of the Colombo Port City, there can be implications for businesses, television and radio channels, web-based internet gambling, advertise in prescription medicines and so on? Can a pharmaceutical firm set up a branch here and advertise prescription medicine, saying that, well, we are doing something from the area of authority of the Colombo Port City? So these are some of the gray areas that need to be clarified, and I'm sure Dr. Asanga Gunawansu, who has been involved with the earlier stages of the drafting of the bill. Actually, I had sight of some of the earlier drafts which are much more explicit and clear than the final bill that was tabled in Parliament. So what are some of the current and emerging challenges? Investors have a long and bitter memory. You remember the nationalization legacy in the 60s, during the time of Mrs. Sirimava Bandaranaike. She nationalized the petroleum industry and we had to pay damages. Then there was a ceiling on housing property law, ceiling on the extent of land that can be held. And even recently, just a few weeks ago, I did hear a minister saying, well, if tea estates don't pay 1,000 rupees to a worker, we can acquire and run these tea estates. So the nationalization legacy still continues to linger on, and I think it is time that the cabinet should decide that there should be only one spokesperson on issues of that nature. The country's risk factor is an important element that will be taken into account when international ratings are given. Offshore banks, for instance, will be going by international ratings, and the very fact that we had to borrow $200 million recently from Bangladesh does not help us to increase our ratings by any means. Then we have the political risk factor, because in Parliament, if you look at the Hansard during the last 2 years, there have been speeches by certain members of Parliament saying that, you know, we are against the Port City Bill. If we come into power, we can scrap and so on. So loose talk of that nature, you know, can harm the country. Policy consistency is something which investors look for, as well as a record of good governance. Then the effectiveness of monitoring money laundering and terrorist funding and the role of PEPs, the politically exposed persons. This is an important area because there are many loopholes in the Act and in the regulations of the Financial Intelligence Unit of the Central Bank, which pave the way for people engaging in money laundering to launder money through the banks in Sri Lanka. Recently there was a case where 600 million came into the country and went to some place in the east to set up a school, I believe, of an international religious organization. So there are questions as to what due diligence was exercised at that particular stage. Then the implications of the Foreign Exchange Act. You recall that the Act did provide that if you have $1 million or less hidden in a foreign bank, which you have not declared to the Commissioner General of Inland Revenue, you have no problem in remitting it to Sri Lanka. But if it is over $1 million, you have to just pay a minimal tax of 1%. And there will be no questions asked, no sanctions at all. So these again did cause much many problems to the Sri Lankan government in terms of commitment to implement anti-money laundering laws and to combat the financing of terrorism. Then there are questions of parliamentary oversight, what documents need to be tabled before Parliament, whether some documents have to be merely tabled or whether they can be considered for debate in Parliament, and also on the role of the Auditor General. But if the Commission is funded by government funds, then the provisions in the Constitution that require the Auditor General to audit the accounts will trigger, and that issue can be sorted out that way. The Act actually provides for international companies to audit the accounts, but the role of the Auditor General will still continue to loom large. So what the policy inconsistency, let me give an example just from 31st May 2021. The heading was, and this is from the Daily FT, BOI not must for ROC to register foreign-owned firms. The government has decided to make the Board of Investments approval mandatory for the Register of Companies to certify foreign-owned entities. A directive to this effect has been sent to the Register of Companies by the Secretary to the His Excellency the President, Dr. P.B. Jayasundara. The Register of Companies has to ensure that applications received for registration of a company by a foreign national or entity are accepted and proceeded and processed only if the BOI's approval has been granted to such an individual or entity to start a project or business operation in Sri Lanka. The BOI has also been instructed to ensure such approvals are processed subject to criteria that will add high value creation activities and a recognized negative list. The one rationale for the new legislation is that there will be a single window for approvals, and in that context it's difficult to understand why directions have been given to the Register of Companies to consult the BOI, which has a mandate of a different nature from the Port Commission. Now with regard to the Financial Intelligence Unit, the unit attached to the Central Bank, which deals with the control of money laundering and the combating of financing of terrorism. The question of the independence has been raised a number of times by the Financial Action Task Force, and it operates under the guidance of the governor of the Central Bank, and at one stage we had a governor with a dubious record who had given instructions for the FIU to take a very lenient view. And in some countries they have gone to the extent of providing for independence in statutes. Malawi in Africa, in the Financial Crimes Act 2017, has an important provision which says, shall not in its functions be subject to the direction or control or influence of any person, authority or entity which may compromise its operational independence. And we need something like the word in that act to be included in our prevention of terrorism legislation. Monitoring and enforcement is relatively weak in this country. The control over politically exposed persons is limited, and information on beneficial ownership should have been made mandatory for any authorized person going to operate within the area of authority. Then there's a huge issue of capacity building. Earlier, some of the staff members were trained following the courses of the International Compliance Association. But during the last 4 or 5 years, the training unit of the Central Bank decided that they don't need any training, and lack of capacity building is a major handicap. And there is provision for an International Commercial Dispute Resolution Center to be located within the area of authority of the CPC, incorporated as a company limited by guarantee. Sri Lankan citizens or residents can serve in any capacity, while an internationally reputed professional may also be so involved. It's a very vague wording. The objective of the center is to offer conciliation, mediation, adjudication, arbitration, and any other alternative dispute resolution. That specifically says it will cover disputes between government and an authorized person or an employee, that is an employee of an authorized person, but whether the government will have a contract with an authorized person's employee is questionable. And the Commission and a resident or occupier, provided there is a binding agreement between them, that these shall be resolved by arbitration. There is a requirement that there should be a mandatory clause included in every contract to refer matters to the International Commercial Dispute Resolution Center. Several years back, way back in 1990, I spent some time studying arbitration and conciliation in China. The preference has been for conciliation rather than for arbitration. So there are also other loopholes in the legislation. What about disputes that might possibly arise between the government or the commission and the project company? So this is not covered in the provisions with regard to the International Commercial Dispute Resolution Center. And I believe if these cannot be settled amicably, either party would have to have recourse to the normal courts of law. Then this section is silent on the applicable law. I won't deal more with this aspect because my colleague, Dr. Asanga, is a specialist in this particular area, and I'm sure he would be able to clarify some of these issues. Then with regard to the Securities and Exchange Commission, it provides that to ensure that the operation of stock exchanges or markets within the area of authority of the Colombo Port City is carried out in an expeditious manner. The Commission may require the SEC to operate an office within the area of authority of the Colombo Port City. The SEC shall ensure that such office is managed by officers of sufficient seniority and authority. But the problem is that the current SEC Act provides only for one exchange, and that is the CSC, Colombo Stock Exchange, and it would need far-reaching amendments to capture such trade-in within the area of authority, and also the power to prosecute for offenses such as insider dealing, price manipulation, and so on. Good governance norms, disclosure regimes, etc. need to be adapted. And where offshore banks are involved, secrecy provisions need to be revisited in order to facilitate prosecutions. Well, I will conclude with these thoughts. The free trade zone is a much needed priority area for Sri Lanka. There is no doubt about that. I used to go to Bangladesh several times from the mid-1970s. In the early 1980s when I went, I found a separate counter at the Dhaka Airport Immigration Center. There was a separate queue for foreign investors. A few years later, I found that that queue was much longer than the queue of normal passengers trying to enter Bangladesh. That's how Bangladesh went far beyond us. In Sri Lanka, we have had several complaints about people who have had to deal with the GCEC, with the BOI, with the Colombo Stock Exchange, and so on. And how much of revenue that will be earned by the government depends on many variables. The Act, despite so many amendments to the bill, still has several provisions which leave much to be desired. The One Belt, One Road initiative needs to complement the master plan. The other day, businessman Dhammika Pereira was interviewed, and he gave a classic example. He said that if 200,000 Sri Lankans are to work within the port city, after they complete their work, how on earth are they going home? Is there a transport network for non-resident workers? Do we have enough buses, trains, or other facilities? So the point which he made is that before the free trade zone can become a fully fledged operation, these things are required, and this is something that can be provided through the One Belt, One Road initiative. Of course, Dhammika Pereira himself was chairman of the BOI, and at that stage some of these issues need to have been addressed. Finally, to gain a prominent place within the Ease of Doing Business Index, many legislative and administrative reforms are required, including a different skill set and a work ethic. Thank you, ladies and gentlemen.
Well, that was Dr. Jayasuriya, who made a comprehensive presentation on some of the legal aspects, some aspects which need to be addressed in the short and in the long term. We move on to our next presentation, salient features of this new Act, Act number 11 of 2021. And to do justice to that is Dr. Asanka Gunawansa. He has had this legislature very close to his heart. He knows inside out of the legislature, and we have no better person than him to deal with this. By the way, Dr. Asanka Gunawansa has a PhD from the National University of Singapore, an LLM from Warwick. He's an attorney at law. He's also the lead consultant of Colombo Law Alliance and adjutant associate professor of the University of Moratuwa. We will now move on to Asanka for his presentation.
Thank you, Malik, for that very generous introduction. And I would also like to thank the organizers as well as the sponsors for having me here. Before I start my presentation, I need to make one correction. I don't take ownership of the current act. I was actually not involved in drafting the current act. But as Dr. Jayasuriya said, my involvement was at an earlier draft that was, I think, at that time considered and approved by the Attorney General. The current act, I would say, is built upon that earlier act, and there are some old provisions still remaining, and there are some new provisions as well. But I'm more familiar with the project itself for the reason that I was involved in negotiating the project agreements on behalf of the project company with the government of Sri Lanka. So that said, my presentation today is on the salient features of the Port City Law and what are the implications for Sri Lankan business. Just to give some introduction to before I actually touch upon the key sections of the Act. As you all know, a bill titled the Colombo Port City Economic Commission Act was debated in Parliament very recently, and prior to that there were also, like Dr. Jayasuriya said, if I'm not mistaken, 19 applications that were made challenging the Act, challenging the bill under Article 121 of the Constitution on the basis that the bill or certain provisions within the bill, right, may be unconstitutional. And their Lordship of the Supreme Court has, there was by way of a 5-judge bench, have communicated their determination to the Speaker, and the Speaker has signed the bill on about the 25th of May 2021, and now the Act is in place, Act number 11 of 2021. So what is this bill about? Now, I will try to avoid overlaps between my presentation and the presentation of previous speakers. So some of the slides I will just skip. But just to give a very brief note on this, the Colombo Port City Economic Commission Act provides the legal framework for setting up of a special economic zone within the Colombo Port City. Now, if you look at if you do a little research on your own on the historical aspects of the development of the Colombo Port City, you can see that, initially this idea of reclaiming land and extending the Colombo business district, goes back to the late 1990s. But when the project was seriously looked at, around 2011, it was initially considered as a real estate development project. Then subsequently the government of Sri Lanka realized the importance of developing this as a financial hub, and with that came the idea of developing Colombo Port City as a special economic zone. And so that is where we are now, and the whole idea of the bill is to provide the legal framework within which the Colombo Port City can operate as a special economic zone. Now that said, in my presentation I wish to cover 3 areas. One, not directly relating to the bill, but there was this question that was asked during the time that the Colombo Port City project itself was challenged in the media, in Parliament, and then even certain questions were raised in the Supreme Court. And some of my legal colleagues, in fact, or some of my law students, also raised this question when they heard that, I was going to talk at this webinar, that is whether there is any truth behind this claim that Port City may not be part of Sri Lanka. So I think we have to deal with that first and, get that off our back. and thereafter look at the salient features of the new law, and also finally I will look at certain implications for Sri Lankan businesses. So the first question is Port City a part of Sri Lanka? Now, to find that answer, we have to look at some background information. As you know, Colombo Port City project has been valued or has been developed with an investment of totally $1.4 billion by the project company. Now, like Mr. Aluvihara said during his presentation, a asset has been created which is owned by the government of Sri Lanka. Now, the person who or the entity that invested in creating that asset will have to recover that investment, and the whole idea of this marketable land being allocated between the government of Sri Lanka and the project company is to give an opportunity to the party who invested that money to recover that investment. So marketable land area is approximately about 170 hectares, and between the government of Sri Lanka and the project company, the division ratio is basically 40 to 60. Now, why would a SCEZ or Special Economic Zone be built in the port city? And what is a Special Economic Zone? So typically, a Special Economic Zone can be defined as a geographically delineated area in a country which is subject to differentiated regulation and administration from the rest of the country for the purpose of attracting foreign direct investment that could not be otherwise achieved. So if you look at some examples such as, say, Dubai International Financial Center, within the financial center, the laws and regulations that are applicable are different to what is applicable outside in the UAE. And in Qatar, the same thing. The laws and regulations that are applicable within the Qatar Financial Center and for those who operate within it are different to what is applicable outside. Singapore, on the other hand, since Singapore is a city-state, the special laws that have been introduced to operate a financial center and grant concessions and so on are applicable within the whole city-state. So a special economic zone, when developed, the popular belief is that it can be successful in facilitating not only national but also regional and global economic development. As we know, Sri Lanka is a lower middle income country with around approximately 22 to 23 million inhabitants. The main economic sectors of Sri Lanka as of today, as we know, is agricultural commodities such as tea, rubber, coconut, gems, tourism, shipping and apparel manufacturing. So we really haven't focused on the service sector. So one of the areas that we need to focus when developing the special economic zone is to see how we can move ahead with this service sector and get the necessary benefits for the country. Now, as we know, Sri Lanka has an abundance of natural resources. The strategic location is ideal for development. However, although we got independence way back in 1948 compared to countries like Singapore, we are lagging behind when it comes to the race for development. Now, I would say that for any country to develop, we can get examples from countries in Southeast Asia, for example, like Singapore, Malaysia, Thailand, even Vietnam, where the development was driven by the development within the central business district. So if we take Colombo as the central business district, in the Colombo city alone, we have about approximately 1 million inhabitants. If you add the metropolitan area, then that goes up to about 2 million. If you take the Colombo district has over 5.6 million inhabitants, making it the most densely populated district in the country. But if I try to identify what is the central business district is, you will find that the central business district of Sri Lanka is in Colombo, but in the old Dutch fort area, which was built in the 16th century. Now, it's a no-brainer. A lot of people will agree that there is hardly any room for expansion in that area. So we definitely need new land in order to expand the Colombo business district so that it can be the driver in inviting foreign direct investment into the country. As you can see from this, my next slide, much of the growth in Sri Lanka has been unplanned, and this is why I say as a central business district there is no room for us to evolve unless we try to focus on building the central business district in the Colombo port city. Now, having said that, I said I will also deal with this fear as to whether Colombo port city is part of Sri Lanka. So, historically, the territory of a state was understood as the naturally formed land in which the state performs its essential functions. However, subsequently, starting from about the late 17th century, there was also recognition that a nation state should have an identifiable maritime territory, especially if it is a coastal state, over which it should have jurisdiction. However, this idea of maritime boundaries for a state became universally enshrined in the modern sense only when this 12 nautical mile territorial sea was formally recognized in the United Nations Convention on Law of the Sea in 1982. So today, this convention, the United Nations Convention on Conference on the Law of the Sea, is regarded as a complete constitution for the oceans. Sri Lanka has been a party to it since 1982. Now, if you look at some of the provisions within this UN Convention on Law of the Sea to identify what is the territorial jurisdiction of Sri Lanka as a nation state, one needs to look at Article 76. Article 76 provides certain rules regarding the defined outer limits of a nation state. And according to these rules, Sri Lanka exercises jurisdiction over the territorial sea, the contiguous zone, the continental shelf, and the exclusive economic zone. I'll explain what these are. Now, the territorial sea of Sri Lanka extends to 22 kilometers or 12 nautical miles beyond the coastline and covers an area of approximately 21,500 square kilometers. The contiguous zone, on the other hand, is the band of water extending from the outer edge of the territorial sea up to about 24 nautical miles. The continental shelf basically covers about 200 nautical miles from the coastline. And the exclusive economic zone extends outwards to about 200 nautical miles and covers an area of approximately 500,000 square kilometers. Now, besides having sovereign rights over the water column, the seabed and the subsurface, as a nation state, Sri Lanka also has the exclusive right to authorize, regulate and control scientific research within this zone. And the sovereignty extends to the airspace as well. Now, so not only the territorial sea, the sovereignty also extends to the airspace. So now, from this slide, you can see very clearly the map of Sri Lanka, and then you will see the outer line. In light blue, you can see the territorial sea, and beyond that, you can see the contiguous zone, and then the greenish blue shaded bigger area is the exclusive economic zone. Then I have put a yes somewhere where the port city is, and it is definitely within the territorial waters of Sri Lanka. So all these stories that, warplanes can come and land and foreign, planes and ships, can come to Colombo port city because it was developed by a developer, there is absolutely no legal truth behind that, because before you cross the territorial waters of a country, you need to get the permission of that country. Now, having said that, we also need to look at how this reclamation project was started and what was the legal basis for that. So, in terms of Section 58 of the State Lands Ordinance, the administration, the control, custody and management of the foreshore of the country is vested in the state. And in the same ordinance, there is a Section 60 which enables the President or gives the President the power to reclaim any part of the foreshore or bed of the sea. So the project agreements with the project company was entered into by the President acting in terms of Section 60 of the State Lands Ordinance and exercising that power. So as a result of that, when the land is reclaimed under the State Lands Ordinance, it automatically becomes part of the territory of Sri Lanka by operation of law. Now, there was also a debate when those 19 cases were filed or applications were filed before the Supreme Court with regard to the same issue. Now, what some of the people who challenge it overlooked is that long before the Act was debated in Parliament, or the bill was debated in Parliament, back in August 2019, there was a gazette published under the Administrative Districts Act number 22 of 1955, annexing the reclaimed area of land as part and parcel of the Administrative District of Colombo. So long before this bill was challenged, the Colombo port city has become part and parcel of Sri Lanka. So therefore, the simple answer to the question, is port city part and parcel of Sri Lanka, is yes. Now, we also need to look at the role played by the project company. I think Tulsi, during his presentation touched on that, but I'm going to give a slightly different aspect. There are project agreements. The main project agreement runs to about 200 pages. It was negotiated over nearly 18 months, very comprehensively drafted, approved by the Attorney General, and that gives protection to the government of Sri Lanka with regard to the reclaimed land and establishes ownership of the government of Sri Lanka. Now, once the reclamation is done, the next step is in terms of the project agreement for the government of Sri Lanka to enter into a master lease with the project company, and it is only through that lease that the project company will get its share of marketable land. So the lessor will remain the government of Sri Lanka, the project company is only a lessee. And Clause 6 of this master lease provides, I will read that section. It says the lessee shall be entitled to commercially exploit the project land for the purpose inter alia of recovery of investment payment of debts and earning profits by developing the project land, by inter alia subleasing, subletting and licensing or otherwise alienating or transferring its interest in the project land to achieve its corporate or commercial objectives. So this right has been given because, as we said earlier, nearly $1.4 billion have been invested, and as an investor, there has to be a return. So in order to get that return, the land that have been leased to the project company can be leased or otherwise alienated as provided in the master lease. So you can't alienate it in any way without the concurrence of the government of Sri Lanka, because the government of Sri Lanka will remain the lessor. Then there were also fears about foreign ownership of land, but we already have a statute called the Land Restriction on Alienation Act of 2014, which has introduced certain restrictions with regard to foreigners owning freehold land, and that restriction will continue to apply with regard to the port city also, unless the act is subsequently amended. So next I would like to move on to some of the key features concerning the act. The key objectives are very clear from the preamble itself, that is to generate new foreign direct investment and attract international economic service providers to conduct business from within the port city. The Act aims to clearly communicate to the investors as well as international financial service providers that the environment has been created with the ease of doing business. There will be incentives available to the investors who would want to come to Sri Lanka. Like Dr. Jayannath Jayasuriya mentioned earlier, that creates the Colombo Port City Commission, which will be the regulatory authority for the port city. There's a licensing requirement to carry on business. We will deal with these in more detail as we move on. So without a license, basically you can't operate. And there are special licensing procedures that have been provided within the Act. The Colombo Port City Commission will act as a single window. Now, this is very important in every special economic zone, be it India, Singapore, or in other countries. The regulator has acted as the single window system to prevent investors from being sent from one window to another window to another window in order to get the necessary approvals and permits, because that will take a lot of time. India made that mistake earlier, which has been corrected in 2019, with the new amendment, as Tulsi pointed out during his presentation. So special incentives and concessions will be granted for operating businesses within the port city, and there is also establishment of a speedy dispute resolution mechanism. The sections that specifically deal with the establishment and composition of the commission are section 3 and 7. Now, as we know from yesterday's news, the 7-member commission has already been appointed, and it says that in making such appointments, the President shall give consideration to the relevant knowledge and expertise and the experience in the fields of investment, finance, law, IT, engineering, business or accountancy. So I take it that these aspects have been looked at in making the appointments, and it's clear from some of the names from the people who have been appointed that they fall within this category. Some others are not known to me, so I can't comment on that. The Commission is responsible for facilitating, preparing, developing, amending, updating, publishing, and enforcing all community rules within the Colombo port city. So, like there are rules, outside the port city, like the municipal rules, the UDA rules, and so on. Here, inside the port city, the community rules will be developed and administered by the commission that has been created. The commission acting as a single window of a facilitator I already mentioned, so I'm not going to touch on that. The commission also needs to seek the concurrence of relevant statutory authorities when issuing the relevant registrations, licenses and permits. So this is very important. In fact, one of the reasons as to why the draft bill was challenged was also due to probably a misunderstanding that the commission will have sweeping powers to disregard the already established regulatory entities within the country and issue licenses and permits on their own, but you can't do that. The Act itself is very clear. It said that it has to be done with the concurrence of the existing legislative entities. Then sections 5 and 6 of the Act deals with the objectives and powers of the Commission, and you can see these are very wide, and I have just listed some of these. For example, some of the powers are to facilitate and exercise regulatory supervision and control over all investments and businesses within the port city, then to lease or grant on freehold basis the marketable land of the government as well as the project company. So here there is a bit of a difference. The project agreement that is currently in place has the land ownership vested with the government of Sri Lanka. UDA has been brought in as a third party to that agreement because the earlier idea was the land will be vested with the UDA, so UDA will act as the lessor. So now with this Act coming into operation, UDA I think will go out of the picture, but the lessor will be the Commission. Then it also says the Commission has the power to develop and approve environmental standards and plan, monitor and execute environmental improvements within the port city, then to cooperate and enter into agreements with other international financial centers globally and regionally, to identify local assessment rates and any other levies within the area of authority of the Colombo port city, then to facilitate the establishment and operation of any stock, precious metal, commodity or exchange market by authorized persons, to prepare and develop, amend, update, publish and enforce community rules, we touched on that earlier, and to regulate gaming activity within the area of authority. So very wide powers have been given. Section 4 of the Act then says that all the development activities within the port city should be done in accordance with the master plan. So this is very important. I showed a slide earlier on in my presentation to see how unplanned the Colombo city is at the moment. So if this is going to be a state-of-the-art CBD or business district of Colombo, then it is important to ensure that the development happens according to this master plan. Section 26 of the Act is also very important because it deals with the requirement to be an authorized person to engage in business. So that is where a license or permit would be required for somebody to operate or carry out business from within the port city. And it says if the person is a company, the company would require the license, and in addition to that, it will also require a certificate of registration issued under Part 7 of the Act. Similar requirement is with regard to offshore banking business as well. It also says every applicant, when making an application to get that relevant license or permit to operate within the port city, will have to specify the total value of the proposed foreign direct investment to be made in any designated foreign currency other than Sri Lankan rupees. So this is very important. If you are an applicant, the applicant, when making that application in order to qualify, has to state the currency in which the investment will be made, and it will be in a currency other than Sri Lankan rupees. Then it's also important to note that the Act says no foreign currency deposit in an account maintained or operated in Sri Lanka or foreign loans raised locally, foreign currency loans raised locally can be used as part of the investment. So in other words, all the required funds will have to be raised overseas. So this is in order to make sure that the investors will not dig into the kitty that is already limited in Sri Lanka, and in true sense of the foreign direct investment, money will come from overseas. Section 32 of the Act deals with the requirement of every authorized person to engage in business in the port city to enter into an agreement with the Commission. So in addition to having the license issued for one to operate, there will also have to be an agreement entered into with the Commission, and it is in this agreement that a provision will have to be included where the investor agrees that if there is any dispute with the Commission, those disputes will be resolved by way of arbitration in terms of Part 13 of the Act, where an International Commercial Dispute Center has been established, which was referred to earlier by Dr. Jayasuriya. Section 35 is also very important because it enables authorized persons who have been permitted to operate within the port city to employ both residents as well as non-residents. This is a key provision because there may be certain expertise that may be required, especially by the international financial service providers and other service providers, which may not be available within Sri Lanka. So in that situation, you will have to tap on foreign talent. Now, countries like Singapore, however developed there, even today, they tap foreign talent. And they give permanent residency, try to attract foreign talent. The idea is not to prevent opportunities for the local employees, but the idea is that from the foreign talent, the local talent pool will grow by learning. Then Section 36 also enables that both employees, foreign and local, will be exempt from income tax. And it also allows receipt of payment in Sri Lankan rupees by an authorized person if services are provided to a Sri Lankan citizen or a Sri Lankan resident. So by some chance, if a Sri Lankan citizen or Sri Lankan resident needs certain services from within the port city from a person who is operating it, then those residents and citizens can pay in Sri Lankan rupees. Section 37 of the Act enables an authorized person, subject to the applicability of existing written laws, to, in the national interest and in order to safeguard the interest of the domestic economy, to seek permission from Commission to operate outside the area of authority of Colombo Port City. Now, this is good and bad. I personally think that there is some clarity required in this section. Hopefully, when the regulations are passed by the Commission, they will add clarity to that. If one reads the Supreme Court decision on this, you will see that Supreme Court also have said where if authorized persons are to be allowed to operate outside the area of authority, then they should not make use of the incentives and concessions given for them to operate within the city to the detriment of those businesses that are operating, competing businesses that are operating outside. So that is very, very important. Section 38 of the Act enables receipt of payment for leases or transfer of property from restricted purchasers in foreign currency. Now, whom I mention as restricted purchasers are those purchasers who can't have freehold land in terms of the Land Restriction on Alienation Act of 2014. So, if they are getting into leases or if they are getting into any property transaction within the port city, then the payment will have to be made in a designated foreign currency. But on the other hand, if those restrictions do not apply to a person, say for example, a Sri Lankan citizen wants to enter into agreement with regard to identify residential plot, then that Sri Lankan individual or Sri Lankan citizen or the resident will be able to make the payment in Sri Lankan rupees. Section 41 of Part 7 of the Act deals with registration of offshore companies, and Section 42 deals with registration of companies engaged in offshore banking. Dr. Jayasuriya dealt with this, so I'm not going to spend time on that due to lack of time. And Sections 43 to 51 of the Act contains several regulatory provisions giving powers to the Commission to regulate offshore companies and offshore banking. And Section 45 in particular provides that when making such regulations, the regulations will have to be passed or regulation will have to be developed with the concurrence of the Monetary Board. So it's very important, again, this is a good example of the existing regulator's role being recognized. And so you can't overlook the existing regulator and go on a voyage of discovery and come up with some regulations which may be challenged later. Part 11 of the Act, namely sections 52 to 53, deals with granting of exemptions or incentives. Now this again, if you read, you will find the necessity to have some clarity, and again this is an area where I hope that when the regulations are passed, the Commission will add some clarity. I'll explain the reason to this. Now when granting concessions and exemptions under section 53(2), the applicant has to be recognized as a business of strategic importance. And the section says it has to be a business of strategic importance which would ensure the success of the objectives in establishing the Colombo port city, having regard to the national interest or in the interest of the advancement of the national economy. Now, how do you define these criteria? Because it can keep shifting from time to time. So that part of it reads more like a policy statement than language found in a statute. But we can take another look at it, when we proceed further. Then Part 11 of the Act further provides that the Commission should give such exemptions and incentives in consultation with the President, or in the event a subject ministry is appointed, in consultation with the Minister. Now the Act does not provide any specific guidelines with regard to granting of exemptions and incentives apart from the sections that we looked at, so those will have to come in the form of regulations. The Supreme Court also in their decision have said that when granting such fiscal exemptions and incentives in accordance with the regulations made under the Act, the approval of the Parliament may have to be obtained with regard to such regulations. Now this is an area where I have some difficulty in understanding what the correct interpretation is. I refer to the term strategic business importance earlier because a business of strategic importance is necessary for you to get those concessions. Now how it is defined? The definition says a business of strategic importance is defined to mean a business that is projected to ensure the success of establishing the Colombo port city. Now that also is more like a policy statement and very vague language in my view, and it says having regard to the national interest or in the interest of the advancement of the national economy, and which is likely to bring economic and social benefit to the country, or is likely to change the landscape of the Colombo port city. So what is meant by that? What is meant by that? Right? Or which will enable global or regional business or service linkage, primarily through, then it lists certain items. So the idea behind this is fabulous in my view, but there may be certain clarity required because there might be always questions raised whether a particular investor was in fact made an application for concession on the basis it's a business of strategic importance or not. Then how do you define it? So therefore, in the guidelines, when the guidelines are developed, maybe further clarity will have to be added. So some of the things to consider whether a business is of strategic importance is to see whether the envisaged transformation of knowledge in terms of promotion of services or development or the use of IT technology, then destination promotion of Sri Lanka as a tourist destination, then the impetus envisaged through promotion of services in the form of Colombo Port City, and so on. Part 11 of the Act deals with the application of the Securities Exchange Commission Act within the port city, and I will leave it to my friend Malik to deal with so that there is no overlap. Now, Part 13 of the Act, which Dr. Jayasuriya briefly spoke about, I also mentioned this earlier, deals with the establishment of an international commercial dispute resolution center. Now, this is very important because although we have an arbitration act in Sri Lanka that has been operations since 1995, Act number 11 of 1995, and although I would say 75 to 80% of commercial agreements entered into Sri Lanka has an arbitration clause, as an arbitration hub, we have a long way to go. There is a very good service provided by the two local national arbitration centers, that is the Arbitration Center of the International Commercial Law, ICLP Center, as well as the Sri Lanka National Arbitration Center, but these have to be upgraded to international standards. Although a few years ago in the World Trade Center, the physical infrastructure was developed to have an international arbitration center for the last 4 or 5 years. Although the building infrastructure is there, we don't have a secretariat to run it. So these are some of the problems that we have had. Now, the idea behind having an international commercial dispute resolution center is good, but then the question is, the implementation. So we hope that by way of regulations, the Commission will, drive that forward. So the center will be established as a company limited by guarantee under the Companies Act of 2007, and it says that it is done for the purpose of offering conciliation, mediation, adjudication, arbitration, and any other alternative dispute resolution services. So there are other dispute resolution services such as executive decision making, mini trials, and so on, which are popularly used, in other parts of the world, and we might be able to piggyback on those and, pick up some ideas and offer them to the clients through this International Arbitration Center, Commercial Dispute Resolution Center. Section 62 of the Act says, any dispute that may arise within the area of authority of the Colombo Port City between the Commission and an authorized person or an employee of an authorized person, where relevant, shall be resolved by way of arbitration conducted by the International Commercial Dispute Resolution Center. Now, here also some clarity is required. I understand that there can be disputes between the Commission and an authorized person, but the reference to an employee here. So, what is the dispute? Is it a dispute that the employee will have with the Commission? If that is the case, there may not be agreement between the employee and the Commission. The agreement will be between the employee and the authorized person. But then the question is, if there is a dispute between the employee and the authorized person, wouldn't the labor laws of the country apply to that? And why would the matter be resolved by arbitration? So some clarity might be required there. Then it also provides that if there's a dispute between the Commission and a resident or an occupier, and then those disputes also shall be resolved by way of arbitration conducted by the International Commercial Dispute Resolution Center. Now, one thing that can be added here, if or at least when clarity is provided by way of regulation, is to say that it shall be finally resolved by arbitration, because from the earlier section you saw the International Commercial Dispute Resolution Center has been established to promote other forms of ADR like conciliation, mediation, negotiations, adjudication. So typically in a dispute resolution clause you have 2 or 3 tiers. You try conciliation, mediation, or adjudication, and if that fails you finally go to arbitration. So in this mandatory language that we find here in section 62(2), which says that it shall be resolved by way of arbitration, it's good to say, but that is as the final tier. Then Dr. Jayasuriya also raised the question earlier as to whether this section addresses possible disputes between the project company and the Commission or the government of Sri Lanka. So the answer to that is no, because the project agreements have already been signed. In the project agreement there is a dispute resolution mechanism already provided, which I think requires the parties to submit to arbitration under UNCITRAL rules, if I am not mistaken, in Singapore. And so unless that section is amended, any disputes between the project company and the government of Sri Lanka will have to be resolved in that way. However, there may be a situation where there might be a need for multi-party arbitration. Now, say for example, under the master lease, the lessee at the moment is the project company. Lessor is the government. So when the project company wants to release its lease to a third-party investor and collect money, these three parties, that is the commission now as the landlord, then the project company as the lessee, and this new investor as the sub-lessee or the new lessee will have to come into a tripartite agreement. Now, in that tripartite agreement, there can be a dispute that may arise, not only between the authorized person and the commission, but the dispute that necessarily involves the project company. Then how do we deal with that? Should those disputes also be submitted to this arbitration center that is created under section 62, or do we allow in that situation for those disputes to be resolved elsewhere? So those are matters that might need some thought. Then section 62(3) says that every authorized person shall ensure that all agreements entered into by them in terms of section 32 shall contain a provision requiring mandatory reference of any dispute to the arbitration center that we looked at. The same section also provides enforcement of any arbitration award made by the International Commercial Dispute Resolution Center shall be done in accordance with the provisions of the Arbitration Act number 11 of 1995. Now here again I have an issue because, as you know, Sri Lanka is a party to the New York Convention. The New York Convention is the Convention on Recognition and Enforcement of Foreign Arbitral Awards. So when in an international arbitration an award is made, the party in whose favor that award has been made should typically have the right to enforce that award in any member country of the New York Convention or the Convention on Enforcement of Foreign Arbitral Awards. So whether we are curtailing that by this, the way this particular section is drafted can be questionable. So perhaps that is another area that might have to be cleared by way of regulations. Then part 14 of the Act provides that priority should be given by courts. So the reference here is to the existing court mechanism in Sri Lanka, but it says priority will be given to any legal proceeding instituted on civil law commercial matters where the cause of action has arisen within the area of Colombo Port City or in relation to any business carried in or from the area of Colombo Port City. So when it comes to enforcement of agreements in Sri Lanka, again our ranking is not very good, and as a result of that, if we are to encourage investors to come in, although alternative dispute resolution processes have been provided for in this Act, there may be situations where one might have to run to court because no arbitration can take place without a supportive role being played by courts. For example, you might have to, for preservation of a subject matter until the arbitral tribunal is constituted, one might have to go to court. Or you might need the assistance of court with regard to appointment of arbitrator, a summoning of a witness, then challenging an arbitral award on certain limited grounds, or even seeking enforcement. So when matters like that go before court, then the court would have to act, very speedily in order to dispose those matters. Otherwise, we will be sending the wrong signal to the investors. So therefore, I think this section is very good. Part 15 of the Act deals with certain interim provisions, and this is to provide that, because as we know, the physical infrastructure or the vertical developments in the port city to be developed will take a number of years. As Tulsi pointed out, certain for the identified plots for the initial development, the infrastructure will be completed approximately in about 1.5 to 2 years' time. So from there onwards, if somebody is to put up a vertical development, you might have to add another year or two. So that is why it is important to allow the business that are coming in to operate from the using the existing landscape in Colombo until the port city is ready to accommodate them. So it is in that context these interim provisions have been introduced, allowing such operations for a period not exceeding 5 years from the date of commencement of the Act. Now, having said all that, what are the implications for Sri Lankan businesses? Is there any need to be worried about? I think not. Well, there are some unclear provisions in the Act, so we can all be hopeful that every statute will go through a teething process, and these can be cleared either by way of amendments or by way of regulation. So going forward, the area that, I have highlighted, areas other experts, who are more senior and experienced than me will highlight, will be addressed, during the process of drafting regulations or by way of amendments to the Act. So Port City Colombo will be an international business and multi-service special economic zone, and operations can be done in any recognized foreign currency, which is good for the nation. It could fill the gap between Dubai and Singapore and to be a much needed vibrant international financial center in South Asia. As you know, South Asia has 1/4 of the world population, but if we need proper international services, such as financial, insurance and so on, we need to look at places like Hong Kong or Malaysia, Kuala Lumpur, Hong Kong or Singapore, or even Dubai for such services, because we don't have such centers in South Asia. So that vacuum can be filled by the Colombo Port City. There is no restriction on local investors participating. Now, what is important to understand is that there is a capital constraint within the country which would prevent local investors from raising enough funds locally in order to participate in certain development projects within the port city. But one should, in my view, in my humble view, should look at that as a incentive rather than a negative feature, because that will give you the opportunity to partner with foreign investors and develop these projects in partnership and let them bring the capital. You can provide the other feeder services, and you can provide the workforce, you can provide the brains, and grow with the investors who will bring the foreign direct investment. So therefore, local business investors can participate in any business activity within the port city, but investment will have to be raised overseas, and for that they will have to partner with foreign investors. The local companies can raise the required project financing by partnering with the overseas companies, as I mentioned to you earlier. And since the focus would be mainly on attracting foreign direct investment for development within the port city and offshore business activity conducted from within the port city, there is unlikely that there is going to be any undue competition with the existing businesses in the country. On the other hand, existing businesses can grow by providing the required feeder services, which Tulsi also mentioned earlier, to those who will be engaged in business activities within the port city. So that is my presentation. I'm sorry if I had gone over my time limit. I'm happy to take questions at the end. Thank you.
Well, in fact, that was a very comprehensive presentation on the operation of this new act. There are concerns and issues with the new provisions of the act which needs clarity, and I think for most of those questions we have got the clarity by that presentation, and we have a whole heap of questions being asked from our viewers on this webinar. Well, it is my task to take a very few 5 to 10 minutes to take you through the applicability of the Securities and Exchange Commission Act. Yes, the section basically clearly states that the Securities and Exchange Commission Act is applicable in the port city. The port city, in fact, is meant to create a paradigm shift not only in Sri Lanka but in the region as well. We are looking at a regional financial center. The capital markets of Sri Lanka, as it is now, it's functioning very well, but in comparison to the region and the world, what we have is a very tiny market. We have a small market. The market we have currently, that is the Colombo Stock Exchange, looking at the paradigm shift, we are looking at least 500 to 1,000 times in the better days of the Colombo port city, the market to be of that size. So, is the Securities and Exchange Commission Act currently, is it sufficient for one to regulate a capital market in the Colombo port city? There has to be a lot of beefing up which needs to be done. New regulations will have to be brought into the SEC Act as well. For starters, the current SEC Act as it stands at the moment will not be a starter for starting up a capital market or a stock exchange in the port city. Why? Because the regulation of the capital markets or a stock exchange in the current form applies only to an exchange. The SEC can license an exchange that is member-driven. Now, member-driven is an old-fashioned form of an exchange, and steps have been taken to demutualize the Colombo Stock Exchange and make it a shareholder-driven stock exchange. I'm not following the slides, but all the slides will be given across to you because of time constraint. Now, the SEC Act, amendments to the SEC Act will have to run very fast if we are to have it applicable to the port city. Because in its current form, you cannot have a foreign investor to come into the port city and start up an exchange, because they don't have the teeth at this moment of time to regulate an exchange which is owned by shareholders. So those are things which we have to fast track, and I hear that there is a proposed act which is going across, and that once that act goes through, then we might be in a position to regulate a stock market in the port city. We might also be mindful to see that the Demutualization Act also runs parallel together with the Act of the Securities and Exchange Commission of Sri Lanka. So once that is done, right, hopefully in the near future, we will have the opportunity of regulating a stock exchange which is run by shareholders. I remember, right, that there is a ceiling of shareholders, a shareholder structure of the exchange, the proposed exchange run by shareholders of a 5%. Now, you're not going to find an investor to come and invest in a stock exchange in the port city having an ownership of only 5%. He's going to bring in a lot of know-how, he's going to bring in a lot of capital, so he would need to bring in more, he would take more in terms of shareholding of the exchange and take ownership, because this is going to be a dynamic financial city. One of the reasons, I think, stemming up from the objectives, you're looking at the Colombo Stock Exchange, you're looking at national interest. You're looking at national interest. But here, you are looking much beyond that. There is an international color, international flavor, which comes into the operation of a financial market in a situation like this. We will also need to be mindful of the regulation that is applicable. I think countries like Singapore and Dubai have run into difficulties in regulating some of the criminal offenses like insider dealing and market manipulation, because what happens is, ideally the port city will have an exchange, and countries from the region like India, maybe Dubai, or maybe Singapore, maybe China, would come and raise capital here. This should be a preferred place to raise capital. And in that instance, the regulator should have teeth to regulate such offenses. For instance, Singapore had issues at one time. For instance, insider dealing offense happening in another country, right? What is the kind of effective regulation you're going to have? So you need to tie up a lot of loose ends, make use of the ISCO uh, memorandum of understanding, which was signed some time ago. There might be similar memorandum of understandings available for people to look at, and also look at more civil regulations. Now that is what I think countries like Singapore and Dubai are moving towards, because it is easy and it is much more expeditious for them to do, because the markets have to function. So the markets have to function. One also will need to be mindful that what will happen in this particular exchange, obviously a future exchange, will have a dollar-denominated board. In fact, the Colombo Stock Exchange also currently, although it is not operation, has a dollar-denominated board, and exchange where our capital account will be closed and will be functioning as a way it should function in the region, and not in a minute way. So my question is, are we geared for such regulation? We need to bring a lot of expertise coming into the regulation, because if we are to find this as a marketplace safe for foreign investors to come. It is not a difficult task. I think the task has to be recognized. We need to work towards it. We need to get professionals to come in. I think Dr. Jayasuriya mentioned that there might need to be an office in the port city. I think looking at the current situation, you might need to have an office which is about 2 to 3 times the expertise that are available currently with the regulator, because you are looking at very big volumes and very complicated financial instruments being traded here in the port city capital market. I think there are certain sections which have been, I see, which are very conducive for that, because the Commission has the power, not the power, to ask concurrence from the SCC, and the SCC is obliged to give concurrence in a very expeditious manner. That goes to show that this is a one-stop shop, right? You cannot be taking time on giving decisions. So that has been factored in to the act. But I think there should be a little bit more meat into this whole thing. And I think this is a start, and I think it's a good thing. We should be looking at it. One of the other things I was just worried was in terms of regulation is there can be arbitrage. Colombo Stock Exchange, there might be a stock trading in rupees, and the similar stock might be trading in dollars in the port city. So there can be a price arbitrage. But if the price arbitrage is very minimum, I don't think that is an issue. But if the price arbitrage is huge, then markets, there will be question marks which have been raised in the markets. But I think these are a bit too premature for us to discuss, because we've just started the new act. There's a lot of work to be done in financial regulation. So we will take it when we cross the bridge. So I would end my very short presentation on this, because we are running short of time. I must also tell you that all these presentations you saw today, by tomorrow, you will have this in your email together with the new act, copy of the new act. So by tomorrow you should have it in your email. If you have not got it, you could ask our webinar coordinator for that, and she will basically promptly respond to you. We have a lot of questions which we have got, but before that, I think you all are also seated there in your office. There is a request that we take a 10 minutes break, a glass of water, right, and we come back to this. Until such time, we will air this, the presentation of the port city. So we'll definitely be back by 4:35 to take on the next questions. Thank you. Will the International Commercial Dispute Center be consisting of Sri Lankan judges? Will the awards be enforceable internationally? And the third question, if an investor with capital are interested to invest in the port city, are there any ready-made projects proposal which the government has made available? We'll start with the third question from Tulsi.
Yes, thank you, Malik. So, as I mentioned on my presentation, close to 100 hectares of land is now ready for development. If you go to our website, there are about 12 RFPs, requests or proposals, that we have floated. Those are in relation to marketable plots of the project company. That includes some pure office development, mixed use. There is also a hotel plot development which is available. So once you have a look at those and evaluate those RFPs, you can directly get in touch with us should you are interested in any particular investment.
I think the next two questions will be to Asanga and also Dr. Jayasuriya.
Yeah, so I'll respond to the question with regard to the foreign judges that have been asked. As you know, it's the International Commercial Dispute Resolution Center which will carry out arbitration. So it will be arbitrators who will be deciding or making determination with regard to the disputes. And the composition of the arbitration tribunal will be based on the wish of the parties. And they can, nominate the arbitrators, or it will be nominated from a list of arbitrators that will be maintained by the International Commercial Dispute Resolution Center. So if the International Commercial Dispute Resolution Center would like to make it attractive for foreign investors, ideally they should have a list consisting of both locally qualified arbitrators as well as foreign arbitrators. And if you look at the region like the Hong Kong International Arbitration Center, Singapore International Arbitration Center, the Asian International Arbitration Center based in Malaysia, they all have list of arbitrators consisting of both local and foreign arbitrators. I think that's the way to go. So we will see it more clearly when the rules of the arbitration center are drafted.
Yes, they should be enforceable under the New York Convention.
Well, we have Roshan Neunheller on screen. Can we get him on screen? He's raised his hand for a question. Well, the question is, can a local company registered under the Companies Act establish its head office in the CPC? The next question is for Tulsi. In the previous webinar, you had a webinar. You mentioned about stopping brain drain and finding better employment opportunities for Sri Lankans in the CPC. How will you intend to compete with local companies?
Shall I answer the last question? So I think I mentioned that typically in any given year, close to about 100,000 people leave our shores for better opportunity. The idea with Port City is really get some of those multinational, big, large brands to come and relocate or expand using the location advantage, as well as we have massive cost advantage. Now, if you compare to hubs like Singapore, Dubai and Hong Kong, in doing business, they are about 3 times costlier than setting up business in Colombo. That includes more from a real estate perspective and also from a manpower perspective. So if we are successful in attracting some of those big brands, and these companies will employ best talent and be paid competitively in foreign currency, I think not only Sri Lankans who are looking to go overseas to work for some of these multinationals will look at an alternate opportunity to work in Port City. Also, Sri Lankans who are currently work within Colombo will also have an opportunity or better opportunity to expand their scope by working for larger companies who will set up in Port City.
I'll put the next question to Dr. Jayasuriya. Can a local company registered under the Companies Act establish its head office in the Colombo Port City?
I think the only requirement will be that they need to bring the funds from overseas, and for that particular rules would have to be enacted.
Well, I'll ask this question for Masanga. Will the Colombo Port City Authority have the power to issue resident visas to foreigners?
Well, that's an interesting question. I didn't see anything specifically providing for that power in the Act. Unless I'm doubtful whether you can even introduce by way of regulation, because there are acts, already in operation which deals with that. So at the moment, no, unless there is an amendment done. Maybe Tulsi, you might want to add something to that.
Obviously, we understand that this area of authority being really positioned to attract foreign companies, expats, foreigners to come and relocate, work here, the visa approval process has to be streamlined, quite efficient. We know inherent issues in the existing system. However, obviously the immigration laws of the land will apply. I think thinking is that there'll be some officers will sit in within the commission to make sure those applications are expeditiously dealt with, and if there are any regulations, further regulations required, those have to be made under the existing immigration law.
Well, there's a question from Mr. Kalum Katapayarachi of DMMC Asset Line Holdings. I think this question to a great extent was answered, but what he's trying to get clarity is a Sri Lankan company having Sri Lankan rupees, having Sri Lankan reserves, having foreign reserves, can he invest in the port city?
So first is any Sri Lankan companies can invest up to 100% in Port City. The restriction is, one is there are two types of investments. One is setting up purely as a business. I think there was a question before whether you can set up your headquarters. Now those will not require massive capital investment. But there will be larger capital investment required if you are going to be putting up any buildings, developing within Port City. So first is Sri Lankans are permitted. The restriction is that if you are bringing capital for development, you need to raise that capital overseas in foreign currency. But up to the value of the land, you can invest in Sri Lankan rupees, subject to the approval of the commission.
There's another question which has been a very long question, but I will try to make it simplify it. The question is that when a foreigner comes in to the Colombo Port City, he invests, he pays for the land by a lease. After that, he will bring all the goods, maybe he's building a hotel or whatever it is, on a duty-free basis, right? And he will do business, and then he will also take the profits out of the country because there is a tax holiday for him. How is Sri Lanka, how will the Sri Lankan economy benefit from situations like this?
Yeah, it's quite a pertinent question. So I think this is not only applicable to Port City. Now, if you look at under BOI, there are sweeping tax exemptions given. Even under the existing Strategic Development Project Act, there are exemptions up to 25 years. So in that instance, what I can tell you is, see, during construction alone, the supply chain impact you create is massive. Let me give you an example of Port City. In the last 3 years, during the reclamation stage, we have provided more than 4,000 job opportunities to Sri Lankans. As we speak now, we have about 15 to 1800 staff working on site. Of that, 80% is Sri Lankan. So you create employment. Second is, I think more importantly, knowledge transfer, especially on the reclamation side. Now, Chinese have built many of such cities elsewhere. One of the examples is the Hong Kong airport, which is about 6 times larger than the port city. Now, when they were doing reclamations, our engineers were working quite closely with them. And that knowledge transfer, I believe, happened. The third is, obviously, there is foreign direct investment, there will be brands. In your example, hotel is not going to go anywhere. Hotel will remain within Sri Lanka, and I think it will definitely create more opportunity. And if we are able to really position our investment competitively, that foreign investor may decide to reinvest their returns within Sri Lanka and not take it out, because finally what they look at is where do I invest my dividend returns, right? Do I get a better return by declaring dividend and taking my profits out, or can I reinvest within Sri Lanka? One of the biggest challenges for foreign investors in reinvestment was the currency risk, because if you look at last 5 years, unfortunately our rupee has depreciated by over 35%. In 2015 it was 145 rupees for a dollar. You know what is it trading at. Now if you look at a large real estate project like Port City, by the time you complete your development, with the depreciation of the rupee, you are left with absolutely next to zero with the rupee depreciation. So here the advantage is that currency depreciation risk is completely taken out, and the currency of transaction is any designated foreign currency, so your returns will be in whatever the foreign designated currency that you have invested in.
Yeah, in fact, that's a very valid answer. In fact, what Sri Lanka has to gain is more than lose, because as Tulsi quite rightly mentioned, there is a market capitalization in terms of land, which is about 7 billion, which will come into the country. Well, if you didn't have this, you would get nothing. But here, you get funding for the 7 billion he was talking about, and even after that, there is also the potential of the opportunity there is for Sri Lankans to benefit throughout this. Although you need to give tax concessions, as quite rightly Tulsi said, but there are more benefits that Sri Lanka is to gain, provided the administration is run properly and in a very expeditious and efficient manner. So, ladies and gentlemen, on behalf of Asian Pathfinder, let me thank you for participating in this webinar. Let me take this opportunity to thank our main sponsors, Czech Port City Private Limited, Mr. Tulsi and his team, and also Daily FT, Mr. Nissa Kasim of Daily FT, for giving us all the publicity, and all the speakers who are present here. We thank you very much for your participation, and we believe that this webinar we've had has been extremely success, and we thank everyone for giving us the opportunity of making this a grand success. Thank you very much, and good evening.
Strategically located along the 21st century maritime Silk Road, Sri Lanka, the pearl of the Indian Ocean, the key link between the East and the West, offers access to a thriving region poised for accelerated growth. Rising from the seas of Sri Lanka, Port City Colombo is a large-scale reclamation and city development project undertaken jointly by China Communications Construction Company, a Fortune 500 company, and the government of Sri Lanka. Spanning 269 hectares, Port City Colombo, when fully developed, will have a total gross floor area of more than 5.7 million square meters. A modern city where people can work, live, and play. The government of Sri Lanka is actively working on turning this into an international financial city. With new commercial legislation modeled after British laws, coupled with preferential tax, custom, immigration regulations, and other attractive policies, Port City Colombo will attract top multinational corporations and global talent. A state-of-the-art convention and exhibition center capable of hosting large-scale international events will position Port City Colombo as the new hub for business and MICE activities in the region. Port City Colombo will also be the pioneer of the smart city concept in Sri Lanka, where IT expertise using cloud computing and the latest cutting-edge technology creates a seamless living environment, making smart living, smart working, and smart estate management a reality. Port City Colombo has adopted the latest sustainable city concepts with emphasis on a people-friendly environment using the transit-oriented developments concept to minimize commuting, further enhances the project's sustainability. Port City Colombo will be the most livable city and desired travel destination in the South Asian region, with a 2-kilometer sandy beach, a water channel that flows through the middle of the city, a central park with lush greenery and park connectors traversing across its length and breadth, with the best of healthcare and education. Port City Colombo will be amongst the very best top international cities, world-class hospitality, integrated resort and theme park, a retail destination that is home to the best of international brands and local retailers, a luxury marina will make Port City Colombo a top tourist destination. Building a world-class city for South Asia. Port City Colombo.